Nice to meet you. My name is Vita Habian-Barbaric. I come from Slovenia. I work in Slovenia with the Commission for the Prevention of Corruption. I'm the head of the Office on Corruption Prevention, and part of my tasks involve lobbying regulation and monitoring how the lobbying regulation is being implemented in practice. I'm also one of the experts in the project, in the component that has been run by Lena, that you already know. And today she asked me to give you a short presentation on international standards on lobbying, and also some of the, let's say, GRECO findings with regard to lobbying regulation in different GRECO member states. And I'm gonna, at the end, just shortly, briefly describe some of the main issues pertaining to the Slovenian law on lobbying. So let me start sharing my presentation. As I mentioned, I will start with presentation of international standards on lobbying, and there aren't many, to be frank. We have the Council of Europe, a few legal documents that have been adopted in 2010 already, calling upon the Committee of Ministers to come up to develop some kind of legal document that would provide rules on conduct of different public officials when they are being contacted by third persons seeking to influence them in the decision-making processes. Then we have the OECD recommendation of the Council on principles for transparency and integrity in lobbying. And then apart from these two, or these two organizations, there is also the European Union, of course, which focused on lobbying and regulated it, but with regards to members of its own institutions. So with regard to how European parliamentarians, members of the European Commission and of the Council of the EU should behave when they come into contact with lobbyists or third persons seeking to influence them. But let me first start with the Council of Europe and the documents, legal texts that they have adopted. At first, I'm going to present the recommendation that was already adopted in 2010 on lobbying in a democratic society. Why is this document so important is that it gives you a description or explanation, provides you with an explanation on the rationale behind lobbying regulations. So why there is a need to regulate lobbying in the first place. And what the Parliamentary Assembly said was that they observed in the preamble of this document that in the recent decades, they have seen that the activities of different interest groups have been constantly increasing, both at the level of the Council of Europe member states as well as at the level of EU institutions. They even say in this preamble that at that time, that was in 2010, there were approximately 2,600 different lobbying organizations or companies registered in Brussels itself. So that's a lot of different people being involved in lobbying activities. So something that you should not ignore. At the same time, the Parliamentary Assembly said that a very important feature of democracy is pluralism of interests. So it recognized that it is legitimate for members of society to organize themselves or either lobby individually or as part of different groups and lobby for their interests. However, it warned against unregulated and secret lobbying because it said that it may undermine democratic principles and good governance. Because in a democracy, all interests ought to be duly taken into account and all citizens should have equal access to the law and decision-making. To put it in a simple way, when you have decision makers making decision, let's say, on certain piece of legislation, you would want them to have access to all those interest groups, experts that have something to say on that particular topic, because this is the way how they will be able to reach an informed decision. If you only allow certain interest groups, and usually that's the groups that have access because of their position, because of the contacts, either political contacts or because of the business contacts, because they're wealthy, because they provide sponsorships, money to political parties, etc. Then you have only a very small portion of those interest groups that have access to the decision making people, while the rest don't. And then you cannot say that the decision that will be adopted at the end of such a process is an informed one, taking into account all different valid views, and that it's democratic because it's not taken in the interest of the public, but in the interest of a small group of people who are connected with the decision-making people. So in this recommendation, the Parliamentary Assembly also noted that there is very few Council of Europe member states that have already regulated lobbying activities. It actually said that there were approximately 14, but only 4 of them actually developed some kind of, let's say, comprehensive lobbying regime. And it said just because of that, because of this scarce number of member states having legislation in place, this may undermine democratic principles and good governance in these member states, because especially in those countries where democratic traditions are not deeply rooted, and where the absence of any effective mechanisms of checks and balances exercised by civil society actually constitutes a danger. Think of countries where there isn't, and these are the practices that have also been observed by GRECO in its evaluations, that you have parliaments in respective member states where negotiations are happening behind closed doors, that people, those that are influencing the politicians, the MPs, are taking part in parliamentary sessions. They are sitting there with the MPs discussing, or at least listening and whispering on what decisions should be made. And none of this, neither who was participating, not what kind of proposals this person provided to the MPs, is made transparent, so that the public can exercise some kind of oversight. There is another observation that was made by the Parliamentary Assembly, and that is that there is a dramatic decline in public confidence in politics in many Council of Europe member states. Usually, we also connect this with corruption in the politics, non-transparent political party funding as well. But they also sort of made a nexus between the lack of transparency in political and economic lobbying activities and with this lack of or decline in public confidence or public trust in the decision-making process. So they, on the other side, what they said was that the citizens have a right to know who is lobbying, so who is trying to influence the decision-making process. And that this is a necessity for enhancing the accountability of decision makers. If you don't know who is influencing them, you cannot hold them accountable. If you know whom they contacted, whom they asked for advice, and whether they were open to different kinds of interest groups, providing their expertise and opinion, Only then they can say that their decision-making process was well informed. So the Parliamentary Assembly said that there is a right to access political decision makers that we, the citizens, have in order to provide them, the decision makers, with the information, and we have to influence their decision making process. So there is this possibility of access or possibility of lobbying that has been recognized by the Parliamentary Assembly in this document as a part of democracy, part of democratic process of decision making. However, it said that access or lobbying possibility must be fair and equal, and it must be transparent and governed by democratic rules. And what does that mean? I already mentioned it at the beginning. It means fair and equal. It means that everybody who is an expert, who has an interest in a certain topic that is being discussed or decided upon, should have the possibility to access those who are making the decisions. It should be transparent, which means that all those who are interested in a particular decision making process should have the possibility to know who had the access to the decision makers. Why? Because only then they can understand why a certain decision was adopted in such or another way, and whether it was only based on a one-sided information or whether different kinds of information, different views were taken into account. And then you can actually do some kind of scrutiny of whether such a decision-making process or the decision reached at the end of it has been not only well informed, but was also taken in the interest of the public as such, and not only in the interest of a small group of those who have access and those who can influence the decision-making process. At the end of this recommendation, the Parliamentary Assembly called upon or recommended to the Committee of Ministers of the Council of Europe to elaborate a European Code of Good Conduct on lobbying. And it also set some ground principles that this European Code of Good Conduct on lobbying should take into account. Number one is that there should be a clear definition of lobbying. And that this clear definition of lobbying should differentiate between lobbying as a professionally compensated activity, so lobbying that has been performed by, let's say, professional lobbyists who do this for money and can be recruited or hired by different interest groups. And on the other hand, and this is very important, you should differentiate between lobbying from the activities of different civil society organizations, including self-regulating entities in different economic sectors. You should think of all those civil society organizations like NGOs that do advocacy, that do some kind of advocating, let's say, for the society as a whole, let's say a right to clean water, which cannot be understood as pertaining to just a small group of people who have a certain interest in the clean water, but it's in the good for the whole society of a particular country. Then another principle that is important is that the transparency in the field of lobbying should be enhanced. And this is done through having the registers of lobbyists open to the public, easily accessible, etc., and to know whom they contacted, whom they tried to influence. Then entities involved in lobbying should be registered. There should be rules applicable to, on one side, I'm going to call them public officials. So everybody who works on behalf of the public sector, even if they are not employed or if they are not office holders, but they are involved somehow in the decision-making process. Because you can have, let's say, a decision of the minister to develop some kind of policy paper, let's say on environmental change and how um, to influence some environmental uh, um, problems, how to do some environmental changes. And the minister could recognize that they don't have enough experts within different ministries, and that it could invite outside experts, let's say from different businesses, from different NGOs. And these would at the same time have to, at that time, uh, understand that they are acting on behalf of the public sector and they should abide by the rules as persons being lobbied, even though they come from the private sector. Then there should be also rules applicable to members of pressure groups and to those interest groups that are trying to influence public officials. So both sides should receive some kind of guidance and rules. What is also important is that the principle of conflict of interest should be laid down, and there should be some kind of a ban on lobbying in a cooling off period. This has been specifically mentioned by the Parliamentary Assembly. It also called upon the Committee of Ministers to envisage that prior to adopting a legislation on lobbying, there are consultations with lobbying organizations on a piece of bill or draft law, and that well-defined and transparent and honest lobbying is encouraged. So it's not just enough to have the rules, but to encourage honest and transparent lobbying. Why is that important? Is because lobbying as such is not a bad thing. The problem is that everybody made it a bad thing. A lot of people, when we talk in everyday discussions, we would say, oh yeah, he was lobbied, he was influenced. But usually we have in mind something negative. The problem is that this notion of this activity being negative also stuck to the lobbying, as it is regulated in many member states of the Council of Europe. Also, for example, in Slovenia, a lot of people still perceive lobbying as something negative, that this is some shady, behind the curtains influencing, which should be prohibited, while it is just the other way around. We should know that it is happening. We should make it transparent, because it's going to happen anyway. The only thing is that we want it to happen in a regulated way and that it's made transparent for everybody to see it. Then all these principles that were mentioned in the previous recommendation of the Parliamentary Assembly were then reiterated in the resolution also adopted by the Parliamentary Assembly in 2010, so in the same year, which is on extra-institutional actors in democratic system. Why I'm mentioning it? Because they are actually repeating some of the very important notions or main foundations of the democratic society. And this is expressing support for political pluralism, which is one of the key principles of democracy. And it at the same time noted that the activities of extra-institutional actors might be beneficial for the decision-making process of a democratic political system. But at the same time, it said that these extra-institutional actors should take into account certain principles or certain safeguards should be put in place. For example, that there should be a framework provided for individuals to associate among themselves and to jointly express views and defend their interests. So, by regulating lobbying, you cannot prohibit individuals from exercising their rights that are usually guaranteed in the Constitution and also in the European Convention on Human Rights to associate. So freedom of association and to petition and to join and collaboratively or individually express their views and their interests. You should also encourage wider participation in public life and to provide opportunities to engage in the political process. And lobbying is one such way. And these extra-institutional actors do, in a way, offer a link between the people and the political institutions. So if we consider interest groups also, let's say, lobbyists as such, as extra-institutional actors, they are the ones that actually make a link between, let's say, business sector and the political institutions. And they allow a better representation of those needs of interest. They provide expert information in the field of their activity, and they at the same time provide additional channels of public oversight over political decisions, because you have to bear in mind that interest groups are going to discuss openly if they are going to find themselves behind in front of the closed doors of decision makers, while other representatives of interest groups will have access to those decision makers. They will raise this matter and they will be loud. And we experienced this in Slovenia. We have actually learned that some political parties in the parliament actually do not wish to speak to lobbyists. They want to speak directly to, let's say, the company and not to the lobbyist as such. And they are rejecting any kind of contact. And this is something that is good to hear and to know how different political parties are behaving and whether they are ignoring certain interest groups. Then, on the basis of what I already mentioned, so both the recommendation and the resolution adopted into the 2010, there was finally a recommendation adopted in 2017 of the Committee of Ministers. And this recommendation actually recommends to member states of the Council of Europe to either establish a legal framework for the regulation of lobbying activities or to further strengthen the existing one. And to, at the same time, ensure that this recommendation, which actually lays down ground rules for lobbying activities and for the regulation of lobbying activities, to be translated and disseminated as widely as possible. And in the appendix to the recommendation, they lay down the guiding principles on devising policy at the national level to regulate lobbying. And what they did is they actually provided, they were quite straightforward. They provided definitions, for example, on what is lobbying, who is lobbyist, who is public official, what is the public decision-making process. And they said that the objective of legal regulation on lobbying should be to promote transparency of lobbying activities. So that's the only objective. It's not to limit it, it's not to prohibit it, but it's to make it transparent. It at the same time said that the activities subject to legal regulation should include activities of consultant lobbyists, so those who do this professionally, so who are hired to promote certain interest of a particular interest group. At the same time, to regulate activities of in-house lobbyists. They should not be ignored. So you can have big companies and they send out their own employees who do lobbying on behalf of those companies because they are their employees. You should not ignore them. I mean, you can have chairmen of different boards of companies, etc. They're very influential people who have access to politicians, and they should not be disregarded. And then at the same time, the subject to legal regulation should be activities of different organizations or bodies that are representing professional or other sectoral interests, like let's say chamber of commerce, or you have trade unions, for example. And if there are any exemptions to this rule, these exemptions should be clearly defined. At the same time, this recommendation recognizes that there is a freedom of expression, freedom of being engaged in different political activities, and freedom to participate in public life. And the legal regulation on lobbying should not infringe in any way these democratic rights of individuals. So at the same time, if I myself as an individual want to, let's say, petition members of the parliament, or if I want to express my opinion on a draft law, I can do it because I'm doing it in my private capacity. I'm not representing any interest group, and I have a right to do this. So you should think about regulating lobbying in a way that you do not, or you already have the law in place, that you not, when implementing the law, when you are going to be assessing contacts between lobbyists and lobbied person, that you're not going to um, um, infringe of the rights of individuals that are related to their freedom of expression, involvement in political activities, or participation in public life. Transparency is another important aspect that should be borne in mind with regard to regulation of lobbying activities. And this is the whole objective of the legal regulation. So to have lobbying activities transparent as possible. So how to make it transparent is to make information on lobbying activities disclosed. And there should be rules on disclosure, which should be proportionate to the importance of the subject matter of the public decision making. So you should not invade on somebody's right to privacy, for example. Register of lobbyists should be public and should be maintained. Lobbyists should be obliged to ensure that the information that they provide and is included in the register is accurate and it's up to date. Because usually on the other side, you have the obligation of the lobbied person to consult this public register to check whether the person in front of them is in fact a registered lobbyist, and hence obligation on his or her side to provide up-to-date and accurate information that is then inserted in the register. If you impose the obligation on the lobbied person to check whether a person in front of him or her is a lobbyist, this access to the public register should be easily accessible and should be user-friendly. So there is actually direct request for this register to be put online, and information that is included in the public register should include at least name and contact details of lobbyists and subject matter of lobbying activities that he or she is lobbying for, and the identity of the client or employer where applicable. At the same time, the legal regulation on lobbying should set down certain rules or standards of ethical behavior, both for lobbyists as well as, on the other hand, for public officials. That's also important. Both sides should have some kind of rules laid down. What is important with regard to the rules pertaining to lobbyists, and I remember that you have them in your law, is that you would want them um, to be guided by the principles of openness, transparency, honesty, and integrity. So when they uh, establish a contact with lobbied person, they are to be open, transparent. They should disclose on behalf of whom they are lobbying, what is their subject matter of interest, what do they want to achieve, that they provide correct information to the lobbied person. If we were talking that lobbying is influencing on the decision-making process, it should be, and if we want to achieve at the end of this an informed decision to be made, then the information that is provided to the lobbied person should be correct, should be accurate, and not false, because in this case, then the decision at the end will only be in favor of a particular group of people. There should be also sanctions envisaged for non-compliance on both sides, and they should be effective, proportionate, and dissuasive. And public sector integrity should be preserved. So there should be measures in place, on the other hand, to avoid risks to public sector integrity. So there could be a cooling off period envisaged. This is very important for, let's say, the ministers, state secretaries, other politicians that are leaving public sector, often being hired by the private sector entities, just because, don't always fool ourselves, not because of their knowledge, sometimes just because they have access to the politicians, because they are or used to be members of different political parties. And they will open doors for these private sector entities. That's the whole purpose why they are why they are being recruited in the private sector. So you could have a minister on informational, let's say, society who is being employed by a big telecom company, of course, because he still has or she still has contacts in the ministry that he or she established while being in the office. He or she still knows whom to call, and if the same political party is in the government, then the door is open to him or to her, and then it's easier to bring in the interest of that private sector entity and to influence the decision-making process. There should be also an oversight, advice, and awareness. Oversight should be entrusted to different designated public authorities. There should be advice provided to both lobbied persons and lobbyists, and there should be awareness raising, especially if you remember that I talked about this negative perception of lobbying that is usually present in the societies. So what GRECO observed in both fourth and fifth evaluation round, when evaluating different GRECO member states, was that in some member states there were no restrictions on contacts between either members of the parliament or persons entrusted with top executive functions, so the executive branch, and the third parties. So there were no restrictions. They could hang out, they could discuss different matters, different public matters, they could be involved in the decision-making process, and there were no restrictions with regard to that. Or there were some restrictions, but maybe no transparency was required with regard to such contacts in terms of disclosure or source. So this was observed by GRECO as even more pervasive among the smallest of GRECO member states in terms of their population. In those member states, it was also observed the existence of direct contacts between, let's say, the business sector and the public sector, the politicians. And these direct contacts were quite common. They were considered as common, as something that is normal, that was accepted by everybody. And if you at the same time know that in certain GRECO member states, let's say members of the parliament were allowed to be involved in different accessory activities, let's say that they could at the same time be still employed with their law firms, then you can understand how easily they were influenced, even through their clients, clients of their law firms that they were still working in, while at the same time being members of the parliament. So there is open door for influencing the decision-making process in the parliament. What GRECO also observed that there was a legal obligation to avoid conflict of interest pertaining to the MPs, but it did not cover ad hoc notifications of conflict of interest. Let's say ad hoc notifications of conflict of interest means that when a situation of conflict of interest occurs that has not been envisaged by law how to deal with that particular situation, you should usually declare it and resolve it prior to being involved in the decision-making process. And in these cases, members of the parliament, for example, were able to have a contact with a lobbyist, but at the same time, there was no legal obligation to that would cover these kind of contacts that would require them to notify, let's say, the president of the parliament or anybody else, let's say the Commission for the Prevention of Corruption, about such a contact. There was also a problem of not having any standards in place that would define what is an appropriate conduct pertaining to members of the parliament or top executives from the executive branch when they come into contact with third parties. So are they supposed to notify anybody? Are they supposed to register the contact? Are they supposed to check whether the person that has been contacting them is in fact a lobbyist, or whom this person is representing? So there were no kind of standards in place. Then another shortcoming of the regulation in place was that disclosure requirements of contacts on the side of the persons entrusted with top executive functions were limited only to a very narrow group of public officials, let's say only to ministers and state secretaries, while leaving out all other persons that influence the minister or the state secretary and can be, because of that, influenced by lobbyists. I'm talking about, let's say, members of the cabinet. Often we saw that ministers could bring in somebody from the outside as a consultant, as an outside expert who could work in the cabinet, either being employed as a civil servant or even on the basis of a contract. And these people were involved in preparing different policy documents and draft laws. And of course, they were influenced by lobbyists and different interest groups. But if the rules on disclosure of this kind of contacts did not also apply to them, the public would know that they were lobbied, in fact. So the GRECO recommendations in most of the countries called for regulation of contacts between lobbyists and public officials, covering also these kind of uh, persons that I mentioned, developing guidelines for public officials and lobbyists that they have to follow when there is a contact that happened, and making these contacts more transparent by identifying on one side the person with whom the public official had a contact, on behalf of whom this person lobbied or contacted the public official, and what was the subject matter, so what they discussed. Um, um, I can, to conclude, I can just briefly mention the experience that we have in Slovenia. Um, we are much, in terms of what we understand as lobbying, we are quite broader compared to Macedonia. Uh, our definition of lobbying is actually involves not only office holders from the executive and the legislative branch of powers, but all office holders and public employees that work in different state bodies. Also, in the Bank of Slovenia, holders are holders of public authority who are responsible for decision making. And lobbying also involves also any activity that pertains to all those persons that somehow participate in the discussion and adoption of regulations or policy documents and decisions. Why we defined this notion of lobbying in such a broad way is because what we wanted to cover is all those people coming from outside that I mentioned. Let's say you're preparing a huge strategy on tourism. So how you're going to promote Macedonia abroad, how you're going to attract tourists, and you don't have the knowledge. Your people in the ministry don't have the knowledge. They don't know how to sell North Macedonia. But you're going to invite people from the private sector, from NGOs, from different associations, from hotels who do know how to do this. And if you understand lobbying that it only pertains to those who are employed in the public sector and involved in the executive and the legislative branch, then you're going to miss on all these people who do take part in the decision-making process. And also, you would want to, at least in Slovenia, we understand that even us, people who work in the, let's say, independent institutions, although we are not understood as really part of the executive branch. Usually when we talk about the executive branch, we have in mind the government and the ministries and administrative units, if we talk about the national level, but then at the local level, we understand the municipalities. But there are also different independent institutions like the Commission for the Prevention of Corruption or the Ombudsman. And you would think, oh, they cannot be lobbied persons, but we can be lobbied persons. For example, we are involved in many activities, like let's say different legislative procedures. We discuss different laws. Just because we monitor the decision-making process, the legislative procedure, and we try to avoid any corruption risks being integrated in the draft law. And we are often part of different working groups within the ministries that are preparing draft laws. And easily we could be lobbied so that we influence the content of the law itself. So we, apart from being involved in concrete legal proceedings, talking about, let's say, court proceedings or proceedings where certain permits are being issued, like administrative proceedings, like, let's say, applying for construction permit. Apart from these kind of concrete proceedings where public bodies are deciding on rights and duties of individuals, pretty much everything is in Slovenia considered as an activity or decision-making process where lobbying can occur. So our understanding of lobbying is much broader than in some member states. I think that also compared to North Macedonia and your legal framework, our is much broader. I will end here. I don't know if Lena has a question for me, because you won't be able to pose any question because this is a recording, but nevertheless.
Let me see. I don't know. You can hear me. I'm not sure if you can see me. I just want to ask you, what was your, when did you adopt the law? How long have you had a law on lobbying in Slovenia?
Well, we adopted the law in 2010. So lobbying has been regulated already for 10 years.
And you have the same law still?
Yeah, I mean, it's been amended in between twice, but yes, it's the same law. What we are doing very much is we are raising awareness on lobbying as being an activity which is an activity that is normal in every democratic society and should be considered or seen, perceived as such. We are also raising awareness of the employees or office holders or anybody involved in the public sector of what is lobbying and how to recognize lobbying and differentiate it from any kind of other contacts that are being made. Especially, you know, sometimes different interest groups or individuals just express an opinion. They send a letter. We believe that you should regulate this or that. We believe that you should change the law so that it would include also this. But there is no legislative process in place at the moment. So this cannot be considered as lobbying. If it were, and these people expressed an interest on behalf of a particular interest group, then this would be considered as lobbying. And then what we also try to achieve is that the representatives of the public sector know what they have to do. So they have to fill out forms, send them to the commission. It's like fill out the report on what happened in the contact itself. And what we do is we publish it on the website. We check every contact and we check it, try to assess whether it in fact was lobbying. So sometimes we ask for further information, and we then, after receiving additional information from, let's say, the ministry or from public official, that
I'm sorry, we can hear you a little bit. Yeah, I think you should.
Yeah, sorry.
Yeah. Sorry.
And then we see that there was no lobbying, that they misunderstood the definition of lobbying. And then we would note this where we publish our lobbying contacts. And at the same time, we educate through these activities lobbied persons so that they understand that the next time they will not report such a contact. And we have different activities going on with the Association of Lobbyists. We just had a huge international conference in the parliament where we discussed how to promote lobbying. I'm talking about the lobbying that is fair and equal and transparent. So I'm talking about this kind of lobbying because at the end of the day, what we want to achieve is that people who do lobby do it openly so that the public knows who is lobbying. And I can give you one example where we found that there was a lot of lobbying, but um, illegal one. It was not reported to the commission, and it involved one government decree on some environmental matter. I'm not going to explain in more detail, but it was an environmental matter which a lot of construction companies had a very huge interest in because it set certain, let's say, thresholds for the damages being paid to the citizens in case that they would suffer from any kind of negative consequences of the environmental, let's say, impact that was a result of the activities of the construction companies. So the construction companies wanted these thresholds to be set very high so that they wouldn't have to pay any damages. And they lobbied. And what we discovered, because we went to look into the whole legislative process to see what was going on at the level of the ministry. So how the ministry's employees were receiving different kind of interest and expert materials because a lot of interest groups were interested, a lot of NGOs, a lot of experts, professors from different faculties that were involved in this topic, in environmental issues. And what we saw was that there was little documentation registered. So the person who was actually preparing this government decree registered almost none of the documents that were coming into the ministry. So it seemed that everything that was written down was invented by him. Which we knew that it didn't happen because we had a lot of information from the NGOs that they were sending a lot of materials. And then because the NGOs were also connected to different kind of experts and they knew who the experts were, we knew that there was some kind of probably deliberate avoidance in registering these kind of documents so that there wouldn't be any legislative footprint, so that people wouldn't know who tried to influence him. Because at the same time, the construction companies were also lobbying, but at a higher level. And he was receiving instructions from the higher level. And he was given instructions to delete certain kind of documents. And this is what we then do when we investigate lobbying regulation not being implemented. This is what we then do. And this is often connected with corruption risks. And it was a big case. As a result, we proposed to the government, to the secretariat of the government, to amend their rules of procedure with regard to what kind of documents they accept and approve and send for the deliberation at the government session. We still have some court proceeding ongoing against the person who was giving the instructions to the person preparing this government decree. So it was an interesting case, and it actually showed that the legislative procedure at the level of the government is not as transparent as it should be, and a lot of influencing is going on. And if there is a lack of integrity on the side of the public officials, you wouldn't know whom they were contacted and on what subject matter.
interest, it also shows something else which is close to my heart, that it's really important that institutions like yours and the one where we are here today are having a really good collaboration with civil society organization. Good. Thank you so much, Vita. You will come to Macedonia, North Macedonia, sorry for that lapsus, in September. I hope to see you here.